Everyone else would go ahead and make your way back into the room so that we can get started on time today. We have a pretty packed rest of the morning for you. But before I introduce the next panel, I want to ask a few favors of folks. Number one, don't forget that there's CLE and CPE sign-up sheets outside at the registration table, so make sure you sign up to get your credit. And also, you'll notice at your table that there's a little slip of paper that asks a couple of really difficult questions for you to answer, like how long have you been a member of iWork, and what does iWork mean to you? If you will take just 5 minutes, it probably will take less than that, to go ahead and fill these out and hand them in to the folks outside at the registration desk. We are revamping the iWork website. And I hope that you will help us in answering these questions so that we can maybe have some good quotes for the website in the future. So to get started today, I want to tell you that we're going to have our next panel. And we're going to talk about this morning is what to do when Uncle Sam is your adversary. And this is a game plan for both litigating and negotiating with the government. Now, our moderator is the Honorable Ann Nevins, who is a bankruptcy judge from New Haven, Connecticut. She was appointed by the Second Circuit in 2015. Prior to her appointment, Judge Nevins worked for 16 years as an assistant U.S. attorney in the District of Connecticut, where she principally represented the government in civil bankruptcy matters, but she also prosecuted bankruptcy-related crimes. In 2011, in fact, Judge Nevins was named the assistant in charge for the Bridgeport, Connecticut office of the U.S. Attorney. Prior to working as a U.S. attorney, Judge Nevins was in private practice for about 10 years, where she represented a variety of clients in bankruptcy matters and also worked on some complex corporate and real estate transactions. So with that, I'm going to ask Judge Nevins to go ahead and introduce her panel. Thank you.
Okay, thank you. Good morning, everybody. My name, as you have heard, is Ann Nevins. What I would like to do first is to thank iWork for having me, and I think all of the panel joins me in that. We appreciate being asked to speak to you today about something that we are very familiar with, and as I've learned as we've prepared for today's panel, I think we each feel strongly about the important role the government can play in litigation and in being a responsible litigator. I'm going to go through and introduce our panel. Each of us comes from a background with government experience. We did not know each other before we got together on this panel, and what's been interesting to me is the number of shared values and shared experiences that we have all had from different parts of the country, different oops, I'm sorry, Siri's talking too. From different parts of the country and different experiences, different agencies, and different, very different communities in which we litigate, but there are some themes that come through. So first of all, I'm going to introduce these folks in alphabetical order. First, we have Bria Colson, who is the senior counsel at Morris James in Delaware. She previously spent time in private practice at 2 different firms for over 13 years and then worked as a trial attorney at the Office of the United States Trustee in Region 3, representing the U.S. Trustees Office in both Chapter 11 and Chapter 7 cases pending in Delaware. Now at Morris James, Bria advises clients on commercial bankruptcy, restructuring, and insolvency matters, represents Chapter 11 debtors, pretty much anybody who could be in bankruptcy, insurers, creditors, committees, liquidating trustees. Outside of bankruptcy, she will represent receivers and assignees and assignments for benefit of creditors and represents corporate clients in asset purchase deals. So she is to my immediate right, that's Bria. We also have Suzanne Kelly, who is a pension benefit expert. She is at the end of the dais here. She comes to us after having spent almost 20 years at the Pension Benefit Guarantee Corporation. She's a pension benefit expert and has more than 25 years of experience in the insolvency field. She has sat on numerous committees, creditors committees in bankruptcy. She's shared with us that her minimum limit was at $1 billion. Suzanne?
During the financial crisis, if it wasn't $1 billion, I would have sat on the committee.
Is your mic working? I just want to see if that's working.
There it is.
There we go.
Yeah, and I sat on 9 committees at once in 2009, so, yeah.
So Suzanne comes to us with that experience, which is fascinating. Now, I want to caution that the Pension Benefit Guarantee Corporation sat on committees. That's the only agency I'm aware of that has participated as a committee member, and we'll get to that when we go through some of our other information. Our other panelist today is Jamie Wilson, coming to us from Alabama. She is an Assistant United States Attorney for the Southern District of Alabama. She, prior to being in the U.S. Attorney's Office, she was a partner at Benton and Centano, LLP in Birmingham, where she primarily focused on bankruptcy and commercial litigation. She serves as the chair of the board of directors of her of the Alabama Bankruptcy and Commercial Law section. And she has also shared with me that in Alabama now, at least the Southern District, the U.S. Attorney's Office has experienced a growth in the number of AUSAs with financial experience in handling financial transactions and bankruptcy and insolvency litigation. So be careful if you're in the Southern District of Alabama. What we want to do today is have a conversation amongst ourselves and also with you by asking you for questions at the end of our presentation. And we want to talk about a number of things about representing the government. And these are intended to be practical tips to the wise on how to interact with government attorneys and so forth. First, I want to give the standard government disclaimer. First of all, we're going to talk about a lot of agencies. I think of it as the alphabet soup. We're going to abbreviate things. If you don't know our abbreviations, please let us know. And then the other thing is that we, of course, disclaim all responsibility for anything we've given you. So, to the extent that we say something today, each of the panelists, is not binding themselves or certainly their agencies to any of our positions, and that goes for our materials as well. I do want to point out we prepared materials that we think are helpful. They include a number of really important things. First of all, there's information regarding things you might expect about the U.S. Trustee Program, the United States Department of Justice, the Pension Benefit Guarantee Corporation, of course. We also have some information about the FCC and SEC, and then we have provided, and we think this is quite important, and it's a mundane matter, but we think it's very important. We have provided the addresses for all the U.S. Attorney's offices in the country and a 2-page sheet on instructions on how to serve the government. That's something that you're going to hear throughout our presentation about notice, service, and how to be sure that you have covered yourself by serving us. And by us, I don't mean myself as a judge, but the agencies that we're talking about. Our panel today has a combined history of over 40 years of, I think, what did we decide, 45? 45 years of experience, and so we're really happy to talk to you today. Okay, so first of all, I'm going to ask you, here's our disclaimer. So nothing we can say can maybe be used against us in the future. The second, we're going to talk today about a hypothetical. We have a hypothetical involving a company called Big Guy, Inc. We're going to have Suzanne run through what the hypothetical is and talk about how that is going to set up our discussion. The themes that we have today that we want to focus on are providing notice to the government. That can be a sticky wicket. That can be difficult, depending on the agency and the speed at which you have to provide notice. We want to talk about some special issues that are implicated in litigation with the government in a bankruptcy case. If you were involved in litigation pre-bankruptcy, there can be some issues that come up that we want to address. We want to also address who is the government in your case? Who exactly is it? And that can be hard to identify. And if you think you know, you need to understand you might not know because the person you think might be calling the shots may not have authority, and they need to get authority, so you need to know that. And then we want to talk about the alphabet soup, individual agencies and some of their special issues. So turning to our hypothetical, Suzanne, why don't you take us through that?
So we're going to talk about Big Guy, and Big Guy is familiar to people because it's elements of lots of cases, I think, that are out there right now. Big Guy's a large multinational corporation. There's multiple separate subsidiaries. Big Guy and some of its subs are all burdened by litigation outcomes. They're either fighting over shoddy products now, or they have judgments against them. And Big Guy and its subsidiaries decide to file for bankruptcy to deal with all of these outstanding liabilities. A few subs don't file because they actually are involved with the government directly on contracts, and if they file, they will lose those contracts. The subs are all independent of Big Guy in the sense that they don't have any joint liability for the judgments against Big Guy, and they don't guarantee Big Guy's debt. Big Guy goes in with the assertion that they're not going to do a 363 sale. This is going to be a pure reorganization. And we forgot to put it down here, but it is my own personal thing, obviously. They have a pension plan. And so while the subs don't have any liability for Big Guy's debt or litigation results, they do have liability for Big Guy's pension plan.
All right, so this raises a number of issues, and I want to ask you, Suzanne, just generally to kind of identify an issue spot for us here. You've identified some of them, and I'm thinking there's going to be tort litigation going on. There might be litigation to and by and against the government involving Big Guy. The subs that may not go into bankruptcy are not going to have the protection of the automatic stay. They might have litigation that continues against them, and how does the bankruptcy affect them? Our hypothetical assumes that our panel here has been asked to take off their government hat and advise Big Guy on what to do and how to handle all of these issues in the bankruptcy. So, Suzanne, taking just some of that, I'm going to move to our next slide, which tries to identify some of these issues. And actually, let me ask Briya if you can run through what some of these issues are.
Sure. One of the first things you should do is talk to your client about what the different governmental organizations are that are involved. Each may have their own regulations, and it's important not to just lump them all together in terms of what needs to be done with one agency is probably different. So the first thing would be to kind of go through what are the different organizations that might be involved. If they're a manufacturer, subject to EPA regulations, union employer, they have a defined benefit pension plan, subject to SEC regulations, and as an employer, subject to OSHA regulations. And then also being a plaintiff in this tax refund suit against the IRS, what issues come up with regard to that?
Okay, so let's talk about that. Jamie, you often represent the IRS in your role as an AUSA. What are some of the issues that can come up when there's a tax refund involved for a debtor?
Well, in this case, it is a bit unusual. Big Guy has had the audacity to sue the IRS and claim that the IRS owes it money. And obviously, normally you see a debtor who owes taxes, but in this case, the debtor claims that the IRS owes it. And in this case, we have a parallel, what I would call a parallel proceeding. We have a tax court case where that litigation is impending. So the first thing that the client needs to be advised of is that if they want that tax court proceeding to proceed on in tax court, somebody needs to file a motion to lift stay. And I can tell you as the government lawyer, I'm going to want a comfort order. I'm going to want that order from the bankruptcy court saying, hey, I know there's tax court, I know there's a case, I know that litigation is ongoing. And in my experience, the bankruptcy judge has always been very thankful not to have a 505 determination, and they're more than happy to let that tax court proceeding go on.
I've never heard of a bankruptcy judge actually wish to consider the tax issue when there's another place that could decide it. Have any of you had that experience? No.
No.
Let me ask you, let me ask the audience, do we have folks who have dealt with government attorneys in the room? Have any of you ever had interactions with the government? And have they gone smoothly? Can I see a show of hands where it's always gone smoothly? Okay, there's a couple, that's good. And so in this case, it's not clear if from my perspective, the refund suit against the IRS, that doesn't seem like that's completely going to be something that goes in Big Guy's favor. Can you talk about that a little bit? And the idea, and what I want to address is set off and some other things. And so when you're dealing with the government, that's something to be aware of.
That's right. Anytime that you have a client that says any governmental agency owes that client something, you should think set off. And you should go ahead and advise the client, hey, do you owe any other governmental agency? Because this refund that you claim could be subject to set off. You may not get it. And that's really important, especially if the debtor is telling other creditors, hey, I got this multi-million-dollar refund coming from the IRS, and I'm going to use those funds to pay your claim, because that may not be the case. And where I see this a lot is in consumer cases. You know, Chapter 13 debtors have a tax refund, but they all owe student loans like everybody else in the world. And if they're in default with the Department of Education, their tax refund is subject to set off. So if you hear of a governmental refund, think you need to have that conversation about the possibility of set off.
Okay, and those set-off issues aren't just related to the IRS. It can be any government agency, I think. Is that right, Brian?
Yeah, I mean, obviously not with regard to the U.S. Trustees Office.
Right,
It's a little bit
right,
different,
that's
but
separate, yep.
I think that is an important point. It's something that I didn't even really realize until we started talking about this, was that for purposes of notice and things like that we'll get into, they're separate, but with regard to amounts owed and refunded, they're not, potentially.
Okay, so what are some of the other things, Suzanne, that you're going to want to be alerting the board to at this stage when they're thinking about possibly filing? We talked a little bit about the automatic stay and how that's going to work, and I think we'll get to some more of that in a bit, or one of our later slides. But you know, if there's litigation that's going on pre-bankruptcy, let's say it's even resulted in a settlement, what do you advise the board about the settlement that they were so happy to approve, and now they're going to be filing bankruptcy?
So the important thing is, your organization, Big Guy, may already be talking to the government, and probably is, in many different areas for mundane things and more esoteric issues. The PBGC in particular probably saw that Big Guy was having trouble and reached out to ask what was going on and had concerns about their ability to fund the plan going forward. And it's always important when you're dealing with the government doesn't do well with surprises. Basically, they hate them. Which you can understand. And if Big Guy has been negotiating a settlement, and maybe they've paid the settlement, maybe it's approved but it hasn't yet been paid, one of the things they're going to want to make sure is that the government knows bankruptcy is an option. Because if you enter into a settlement with the government, and if you've paid it, there's some risk that the government has to disgorge the money back to the estate. This is not a happy thing for government to do. If you haven't paid it, and then the question becomes, the government may go to court itself and say, I want to void the deal. I didn't know they were going to go into bankruptcy. I wouldn't have agreed to this if I knew they were going to go into bankruptcy. So it's always important.
And then at that point, they might call Jamie and say, can you figure out what, did they
Right.
defraud me?
Did they defraud me? They're going to look at it. And if your settlement's in process, it's going to stop. So if you were counting on this quick bankruptcy because you knew you had the settlement lined up to be signed, you can forget that. And the more dollars, I think we said the more dollars involved, the more signatures it needs. And that's with any agency. And once you're in bankruptcy now, where you may have dealt with an agency directly, not PBGC, you'll still continue to deal with them directly, but with all the other agencies, now you're going to go through justice, because justice is going to be their counsel in the bankruptcy process. So it's going to be very important for Big Guy to understand who they've been dealing with, who their contacts are, and what they have promised or not promised in this time frame, and then let people know. Give them a heads up as to what's coming as soon as they can. And don't sign any more deals. If you're about to file for bankruptcy and you haven't told people that, be very careful. PBGC itself had a case where, and it wasn't even a bankruptcy filing, where they didn't reach a settlement because the company had represented that they weren't closing the deal for another 2 weeks, and then closed on a Monday morning. And, I think the litigation's still ongoing over that,
Yeah, so one thing that I think is very interesting is we had a panel this morning, which I thought was fascinating, about rights offerings, and the big takeaways that I had from that were plan early, think early, act early, learn your facts early, and I think that applies here as well, that when you're dealing with the government, I think all of our experience has been that, you know, the government is a big ship, and it can't turn on a dime, to mix metaphors a little bit. Let's talk about, yes.
Actually, the one other thing too is, and we talked about this yesterday, is the government wants to help you. The
Right.
people you're dealing with in the government don't want to litigate with you longer than they have to. They don't want things to become a mess. They want to work with you to make it go as smoothly as it possibly can. And they want to be able to, you know, because the person you're dealing with probably doesn't have settlement authority and has to run it up the chain. You don't want to put them in a position where they have to go back and say, you know, I sold you this deal, but now the facts have changed tremendously. It's really hard for them to help you when you do that.
And I would add to that, you know, if you're pre-bankruptcy and you've negotiated a settlement with general counsel for some agency and that deal has blown up, you know, I understand deals blow up. But I think the best thing that you can do when you see that the deal is not going to go, pick up the phone and go ahead and call agency counsel or call your local AUSA and give them the heads up and say, hey, we really tried to work this deal, but it's blown up. It's not going to go forward. I'm giving you this courtesy call because I want you to be able to explain to your agency why this deal blew up and why we were not in bad faith. And that will put you on the right track when you do get to bankruptcy, because you're going to be dealing with those same people again.
And let's just talk about calling an AUSA as opposed to the trial attorney for the U.S. Trustees Office. They're both the Department of Justice. Can you guys explain how they're the same and how they're different?
Right, they're both Department of Justice, but they're different. They're different functions, different roles. The trustee doesn't come in until after the case has been filed, so there's no pre-bankruptcy litigation, settlement discussions. So it's helpful to let the trial attorney know if there were any deals or things that may affect the bankruptcy. Like we've talked about, I think the more information up front, the better. But just because you tell the trial attorney about something, it may not ever, probably won't ever get to the U.S. Attorney's Office. So it's important to
And some of
call
that is
off.
because, right, the U.S. Trustees program is really a standalone program, whereas, Jamie, can you talk a little bit about what is, you know, the portfolio, if you will, of the U.S. Attorney and all of the assistants in each district?
So as an AUSA, I represent the United States and its agencies. And, you know, typically I represent the IRS, the SBA, the Department of Education, the Department of Justice if I need to enforce the restitution lien. There's only a few agencies that don't use local AUSAs like the SEC. But if you have a governmental agency, or you think you have a governmental agency, or you're just really not sure, if you will call your local AUSA, they can point you in the right direction and help you figure out what agency you really need to serve. Because we realize sometimes that is not clear. And we're happy to help you figure out who that person is.
And the other thing is there are a number of agencies. So when you talk about agencies, right, the government agencies, if you think about it and go back to the Constitution, the United States Attorney is part of the Department of Justice, an executive agency under the president, a cabinet level agency. The U.S. Attorney is charged with being the government's lawyer in court for every agency that is within the executive branch. It also represents the armed forces. In my own career, I had a lot of cases with parts of the armed forces that I didn't know exist. And again, there were defense reutilization materials service. There were kind of some interesting little pockets that would have claims in cases or roles in cases. But there are some that have independent litigation authority. PBGC is one of them. FDIC is one of them. I believe Department of Labor is one of them and can come in. So we talked a little bit about the union employees and pension funds. Usually when there are problems with not usually, but at times, when there are problems with pension funds, there may also be problems with health benefit plans or with other employee benefit plans, and you'll see the Department of Labor involved in a case. So this is a really hard thing for looking outside the government to figure out who is the government agency, who do you give notice to, and maybe this would be a good time to talk about notice. So turning to our next slide. So there are some very specific rules about giving notice of contested matters and anything where you're going to alter the rights of the other party, or in this case, the government. And we've got a couple pages in the materials, pages 6 through 12, that we hope are helpful. So Jamie, just again, I'm turning to you as the one who currently is lucky enough to be on the receiving end of all this notice. How do people provide notice to government agencies?
Well, I think the first thing that attorneys should realize is that the United States is never, and I do mean never, going to waive service. So it's really important that if you have something, that you get the service correct on it. And there's always 3 people that you serve when you have a governmental agency. It's the local United States attorney in your district, it's the Attorney General for the United States, and then it's the agency. So just always remember that there are 3 people that you need to serve. It's
So
less
if you
than-
have a $1 billion problem, those are the 3.
That's right.
And if you have a $500 problem, those are the 3. Is that
Yes.
right?
And think about it this way, it's gonna cost you less than $2 to serve us. If you do not serve us and you get an order, first of all, the United States is not gonna let you take a default against us. And we are not subject to negative notice. So if you do by chance get an order where you haven't served us correctly, I'm gonna set aside that order. And if that order had something to do with a deadline, like an objection to claim, where you objected to an IRS claim and you got an order but service wasn't correct, I'm gonna have that order undone or vacated, and then you may have a deadline problem. So always start from the beginning and make sure you get us served.
Yeah.
And if I have to deal with like 4 different government agencies, do I only have to serve you once? Or do I have to serve can I just send it to you and the Attorney General and be done? Or how does that work?
So say you have something that, like a regular pleading, and you want to be sure that you've got everybody. On your certificate of service, you would have the U.S. Attorney for the district, the Attorney General of the United States, then you could have IRS, Social Security, FDA, and you can have all your agencies like that.
But if I serve you and I have FDA, but I forgot to put Treasury down, am I safe?
Nope, you didn't serve Treasury.
And then the U.S. trustee is obviously a separate party that needs to be served
Yeah.
as well. And when I was in private practice before going to the trustee's office, I didn't do this, but I saw a situation where a debtor didn't serve the appropriate governmental agencies, and the court did vacate the order.
The other thing I would mention too is, besides your service requirements under the bankruptcy code, individual agencies may have their own reporting requirements that you are required to fulfill if you file for bankruptcy. PBGC has them, where you have to send a separate filing to them in addition to the service. So if you don't serve the government, you're in trouble. But if all you do is serve the government and they have a separate reporting requirement and you don't do that, it's just a different kind of trouble. So it's important, again, for once the big guy understands who they're dealing with and what all their bankruptcy commitments are, do they have any other side commitments that they still need to deal with separate and apart from that?
And 7004 is strictly applied. So it's not going to work if you're debtor's counsel and you get up to the podium and you're like, well, I called AUSA Wilson. I told her, she knew. That's not going to work. You have to strictly comply with 7004.
Well, the other thing is, just because the debtor's aware that there's an agency involved in a case, is it fair to say that the U.S. Attorney's Office may not yet know? So, for example, do you have authority to just walk into court for every agency that shows up on the creditor list, or do you depend on referrals from specific agencies?
No, that is a common misconception. In the Southern District of Alabama, we have dockets every single week, and I'm usually on every single docket, and I can't tell you how many attorneys were like, you were there? Well, I was there, but I was there on another case that I had a specific referral on. For instance, I can't just, show up in some bankruptcy court in the Southern District of Alabama and appear on behalf of the IRS without a referral from the IRS. Now, what happens is if I do see something on the docket that I haven't been served with that has to do with a governmental agency, I'll call the governmental agency and say, hey, I see this on the docket. Have we been served? More than likely not, and that's why it hasn't already come to me. And I try to be proactive about it. But yeah, just because you see an AUSA sitting there, it doesn't mean that they're sitting there on a case that they haven't been served with.
And it's important, this isn't just business. This is individual creditors as well as business creditors, where you have these same issues, education for loans, tax purposes. So it doesn't matter where you practice or what kind of practice you engage in, like it's important to get the government service right across the board.
And I'll say that another misconception, I'm on every docket, and sometimes you'll hear things on the docket and you think, person probably should have, Fifth Amendment issues. You hear things that you know are probably going to result in a criminal referral. Just because you see a civil AUSA sitting there, it doesn't mean that that civil AUSA can make that criminal referral. So don't assume that just because you see somebody there from Department of Justice that a criminal matter is going to get referred just because that AUSA saw it.
So that speaks a little bit to the idea of who is the government. And so I want to talk, and I want to emphasize this, I guess, because I think I've seen it surprise people in cases, that on the one hand, the government demands service for each agency to be very technically perfect, really. And one thing that was interesting to me when we got to know each other preparing for this panel is that I agree with the concept that the government doesn't waive notice. That was certainly the policy in the District of Connecticut and every training I ever went to nationwide for DOJ. So that's important to understand. But it doesn't have to be serviced by any special means. It can be, U.S. mail 50-cent stamp, basically. And then the other thing is that although there's an adherence to the technical service of each agency, once served, then the government is a unitary creditor at some point, and that there's this idea about set-off and recoupment that can hurt a case if the lawyers are not prepared at the beginning for that concept. So information is what you're talking about, though, that you're hearing something that might result in a criminal referral. On the one hand, you don't want to scare everybody, but on the other hand, if it's public record and there's something that is compromising for someone, should folks expect that might get reported back at some level?
Yes. And, you see things in bankruptcy court, if you attend enough dockets, you hear things and you're like, well, you probably should have disclosed that yacht. I mean, that's probably going to result, and everybody in the courtroom knows it's going to, or it should result in a referral. But it actually has to happen. It has to follow the correct procedure. So just because you see a government lawyer in the courtroom, none of that procedure is waived. You still have to jump through all the hoops to make that referral happen.
And then turning to our next topic here, we've got another slide about litigating with the government. We touched on this a little bit before about pre-petition settlements, post-petition settlements. I'd like to talk a little bit too about, how to manage people's expectations about litigation. So with regard to the big guy board, Brian, how would you manage folks' expectation about, how is the automatic stay going to play in the litigation? In our hypothetical, big guy is the one that is contemplating the bankruptcy, but all the subsidiaries may not. And so if they're all involved in litigation, how is that going to play out?
Right, definitely need to seek the comfort order of a relief from the stay to be able to proceed. You don't want to...
Or sometimes I've seen folks do the opposite, right, is to get a stay to extend to the subsidiaries,
right,
at least for a breathing period to figure out what's going on.
Right.
Okay, and have you had experience with, other counsel where you've got one agency coming that was litigating pre-petition, and all of a sudden you have a change of characters the cast of characters changes once the bankruptcy's filed. How does that work?
Yeah, no, with the trustee's office, it's a little bit different because you're just coming in clean when the bankruptcy is filed. But there are, the AUSA with regard to the bankruptcy issues is now going to be the face that you're going to see. But I think we talked about how the information will be shared. And then just in terms of helpfulness, whoever you see will want to help you. The governmental lawyers are not there to block deals. That's not their motivation. And I know there a lot of times people feel like they're coming up against a brick wall with regard to, well, this was moving so smoothly before we filed, now what's going on? But that's
Well,
just something
Let's
to let.
talk a little bit about that motivation, right? So one other thing that was really nice is to talk with everyone and realize that, most people come into government service because they're trying to work in a place where part of the discussion is how to do the right thing. And as corny as that sounds, it actually is a very big part of what's discussed at government agencies, especially the federal agencies that we all used to or currently work at. But what other motivation issues do you find? So in your role as representing the U.S. Trustee's Office, money wasn't the goal, right? And sometimes policy in your district might not have been the goal. Can you talk about that a little bit and the challenges from the perspective of a trial attorney for the U.S. trustee that has to go into court and take an unpopular position?
Yeah, that
How
happens
does that
a
work?
lot. Yeah, it happens a lot.
I'm pretty sure that anybody who's been involved in a Chapter 11 case or a Chapter 7 case involving the trustee has experienced this effect, right?
Yeah, I saw it a lot, especially in Delaware, where there were these big cases trying to get them through with deals that had been cut with all the economic parties. And even though they know they're going to lose, a lot of times the trial attorney has to go in there and make these arguments because of a bigger policy implication, whether it be a national initiative or something like that. And I think a lot of times people are frustrated because they think this is a change in position. Wait a minute, you didn't do this before, but it's, again, you have to be cognizant of the fact that the government is this big entity. There's different things coming up all the time, and it's not an economic motivation. And so there's things constantly moving, that it's not a new position, but there's now different policy implications that are in play just because of the evolution of the practice or different types of deals that are being struck. And then it's a reaction of, well, wait a minute, how does this fit in with this bigger policy?
And so I think, have you all had the experience of being the dark cloud in the room as well?
Yes.
That to put the kibosh on whatever the situation is. And does that, can you talk a little bit about motivation of the agencies that you have experience with?
So at the PBGC, people think it's very dollar and cents because you're talking about the liability of a pension plan, and it is. But even there, the most important thing is the policy implication. And so we'll go in or I would go in and try to do a deal, and people would be very insistent about something. And I would say, look, we can fight this, but understand we're looking for a test case. We have a split decision. We're trying to take it up to the Supreme Court. Even if we lose, we don't care. We're not doing a cost-benefit analysis. It's going to cost us X dollars. We're staff, right? We're getting paid regardless. There's no bigger bonus or smaller bonus. It's hard to get smaller.
Unless there's a government shutdown. But
Yes, unless
yeah.
there's government. But so we're going to litigate that issue. So when you're trying to make a settlement deal, figure out ahead of time, and you can even ask, what are the policy implications? Like, what do we really care about here? What do they care about? And how do we work that into the deal? Because there are ways, and I'll give one example that's very PBGC specific, which is PBGC calculates the underfunding claim a very specific way, and that's the way they want it calculated. So they're not going to compromise what their approved claim is. Where they compromise and where they get around it, and have gotten around it in the past at least, is to say, okay, you agree we have $1 billion claim, but we'll take the first level of recovery on $500 million, and only after a threshold is met will we take recovery against the next $500 million, and you all know the threshold is never going to be met, or most of the time isn't going to be met. And so they get their policy issue protected, and you get the settlement that you need in order for the case to move forward. Because, as I said, PBGC certainly will litigate to get even to lose, to draw, as they call it, to draw the lines around what the parameters are. one of PBGC's biggest cases was the LTV steel cases in the 80s. And what LTV did was start a new plan after terminating their plan, and PBG said, no way, we took your pension liability, you can't have a new plan. And they litigated, and they lost. And they continued to lose all the way to the Supreme Court. And then they won. And because they won at the Supreme Court, they were able to give LTV back its pension plan, right? Huge plan, lots of people, tons of work. I'm not even sure they successfully gave it back before they then had to take it again because LTV really couldn't afford the plan. They didn't care. What
So
they
they
cared
were
about was
gonna-
the principle.
They were going to die on the hill on their principle.
Happily.
And I'm sure it drove everyone in the case mad. And is that fair to say? Because you couldn't fix it with money, you couldn't fix it with a negotiation, but sometimes you can,
Sometimes
right?
you can.
And-
If you can give them the principle they want, there are ways to work around it economically.
And so let's talk about that, because my experience when I was at DOJ was that for a quirk in the way that Medicare and Medicaid are funded in Connecticut and the way that the state authorizes Medicaid beds, there was a rash of healthcare nursing home cases in the late 2000s where 50 or 60 nursing homes filed bankruptcy. Horrible cases because you can't convert the case, you can't liquidate. The thing that was interesting is that I found the creditors who are trying to get financing orders under 364 and cash collateral orders to be very frustrated with what Medicare and Medicaid were worried about. And Medicaid and Medicare at the agency level were coming back with very technical objections to simple, or what should have been simple, first-day cash collateral orders. And finally, I just drafted a few paragraphs that everybody could live with, and that became the paragraphs that are used now in nursing home cases in Connecticut, which still come up. So in talking with all of you, it seems to me that you had the same experience. U.S. Trustee's Office, you frequently will have boilerplate language that's acceptable, right?
Right, and that's sometimes what's frustrating is that it's a lot of times it was reinventing the wheel, even with the same debtors counsel.
Yeah.
Sometimes I think the perception internally is, are they trying to pull a fast one and try to get away
Right.
with something? But generally, people are busy, and so I think it is important, to the extent that you have been provided with language that you've agreed to in the past, if you can do as well, as much as possible to get that in there. And I think one of the larger considerations that the trustee's office has also is, how will this affect the next case? Will this
Right.
be used against me? And I don't know if your agencies have a similar type of concern with regard
Always.
to any resolutions.
Which is why, like, PBGC would give out standard language on different issues. And I think some people thought, well, it's close enough, right? I dropped a word or I changed a word or something, and no one's even going to notice. Well, they're going to notice, and it's not approved, right? So they're going to be concerned about why you did that. Was it accidental? Was it malicious? What was it? How does it impact us? And oh, by the way, now that you're not using my approved language, don't be in a hurry to get a response back, because now it's starting from scratch again. You could have rewritten the entire thing as the same as dropping a word that you don't want to put back in. And that can take a lot of time, and lack of planning on your part is not an emergency on their part, right? The people who need to approve it may not be available to approve it. Your case may be very big to you, but in the context of what else the agency's working on, it may not be the highest priority.
That's
And
right. And
so-
if you have a government agency involved in your plan, they're going to have language. I mean, they
Yeah.
are. Um, it-
They're
Whether
going to
you know
have
it or
language
not.
about your release language. They're going to have concerns about that. There are certain, trigger points that are always going to be there.
That's right. And if you have a governmental agency, I think you save a lot of time by calling the AUSA and say, hey, I'm drafting the plan. This is how I've treated your claim. Can you take a look at it? And I'll have debtors counsel send me that portion of the plan. I'll go ahead and redline it, put in whatever language, and I'll send it up to the agency for review, and that saves the debtors counsel a lot of time. If you haul off and just file a plan that doesn't have my special language in, all you're going to do is draw an objection and push it on down the road.
And everyone you deal with wants to help you get it right the first or the second time. Like, They don't want to extend how long they have to do it. They don't want to have to go through 12 iterations with you. They don't want to have to run it up a chain 10 times. They want to help you. They want to move the process forward.
So let's talk about this chain a little bit. So, I think many folks have the experience of dealing with the Office of the U.S. Trustee and being able to make deals in the hallway. In my courthouse, there's a hallway where everybody stands and horse trades, basically. But sometimes that's not possible. Is that right? And it
Right,
depends on the
yes.
issue.
Yeah, a lot of times there is certain policy issues or bigger issues that have bigger implications where you're not going to be able to get the U.S. trustee to agree.
And I think sometimes the frustration with dealing with the government is that you think the government is this person. Bria's the government. She's the one. But sometimes there are things driving that you either because they don't bring it to you, you don't have the capability of responding right away.
Right, I might not even, or I might not have even realized
Right,
fully what the implications
Right,
were.
because it's evolving. All right. And with regard to a compromise, can you talk a little bit, Jamie, without giving away too many secrets, about how does a compromise get approved? Is that something that you have authority as an AUSA, as the lawyer who stands up and says, I represent the United States of America? Do you have the ability to sign and compromise a claim?
No, just a regular line AUSA does not. But, going back to what we said earlier, more money, more signatures. So what happens in reality is, you're working with an AUSA and you may work some general terms out, and then the AUSA will do a memo to the civil chief, and this process will start going. And depending on the amount of the claim, we figure out who needs to sign off on it, but it is a multi-step process. And so you have people weighing in on each level. And part of that is because as the process goes, not only do you want to work the amount of the claim, but you want to be sure that you're conforming to DOJ policy and that you're respectful of the policy and how other jurisdictions are treating similar issues. So there's more that goes into it than just we're going to agree on the amount of the claim.
And the person who's representing for you inside the agency, again, wants to help you. But they need to know as much as possible because someone's going to ask a weird question. Well, are similarly situated creditors getting the same? Are we giving up something we have a right to? And why are we doing that, right? What are we getting out of it? Where all the policy pieces hit. And people care a lot about that. And there are small enough cases at PBGC where the person in the room actually has settlement authority. They're still not going to settle in the room with you because they're going to go back and shop that solution around with everybody else because their reputation's on the line with it. And so they need to understand what's going on and why it's going on and what it needs to be. And they will be your advocate. If you work with them and partner with them, they are happy to advocate for you. I can't tell you the number of times I sat and talked and cut deals and people said, well, is this a deal? I said, no, I don't have any authority to settle this, but I can sell this. And that's what you need. You need a partner in the agency to help you get the deal done.
Well, and that's where all the early notice comes in, right? Is being able to give your advocate within the agency, which might be the AUSA, it might be the trial attorney in the U.S. Trustees Office, it might be an agency representative, to give them ammunition and I can't emphasize enough how important it is to be straight with people and just, try and provide good information, because the government doesn't, as much as it can't turn its position quickly, it also doesn't react well when it feels it's been misled. That's probably an obvious point, but.
And going back to the amounts, like I have a case right now where it's a very large amount and it requires DAG, Deputy Attorney General of the United States, to sign off on it.
That's the number 3 person at DOJ.
Yeah. So it's a big claim, and so what I've told debtors counsel is, hey, we'll get this part started, we'll go ahead and start trying to get our approvals, but now we'll get this part started and you go work on your other creditors. So don't put a governmental agency at the last of your list of people to work your deal out with. You need to bump the government agency up to the top of that list, knowing that it's going to take us longer. So try to, I know government's always on the last of everybody's list. I mean, I get it.
The
But
government
for-
can be a good ally in court, though, if you get them
true.
on your side. Let me ask you, so we have just a few minutes left that we just want to inquire. We probably could keep talking here, but I want to find out if there are any questions, if anyone in the room has questions for the panel.
Yeah, we do.
And I see some, to be honest,
hard
it's
with the
hard to
light.
see.
There's one back there and one there.
So I have a question regarding, I can project really loud.
We can hear you,
We can
yeah.
hear you.
So, how do you handle conflicts between different agencies? And I'm asking because I had a very specific situation where I'm a panel trustee. I had filed a motion under 724 where the IRS had a lien. And the agency at the IRS, they wanted us to go through with them. They'd been trying to foreclose on this property for years. So we were actually even though we filed a complaint, they actually wanted us to go along with it. But they refused to take a position in court to support us when the U.S. trustee was not supporting my position because the property was underwater. And so I found the whole dynamic very interesting that, you know,
It's weird, isn't it? It's all DOJ, shouldn't they get along? Yeah,
so how does that work?
yeah. I have a solution for you, I'll talk to you later. But Brian, what's your?
I think sometimes there is tension because the U.S. Trustee's Office, even though it's under the umbrella of the DOJ, is a very discrete role in the sense of not worrying about economics, not worrying about individual agencies. It's what is the right thing under the code. And so sometimes there will be situations, I saw them, where there's some tension. And sometimes they'll defer and sometimes they won't, depending on the policy implications.
And to get very specific, when you have multiple agencies in a case, when you're doing a plan or a settlement or something where you're saying the United States, when you have multiple agencies, you have to be very careful about saying, identifying the agency, because when you just say the United States, well, the rest of the world doesn't know which agency you're talking about, and I've seen cases get really sideways where there's been some plan file talking about the United States. Well, which agency? So the agencies should be very careful to make sure it's very clear about which agency they're talking about in your pleadings.
And also, and this PBGC again is unique in this way because we sit on committees, has a whole different access to information than another government agency might have. But the PBGC is also bound by confidentiality agreements, so they can't just hand it over to the assistant U.S. trustee or anyone else.
I do think that is specific to some
is.
agencies, because I do think there's a lot of sharing that folks may not be aware of between other executive
Right.
branch agencies.
Right, but because of the committee's representation and sometimes just what the debtor gives us, there's only an ability to share up. And so I've had a case where, EPA came over and said, well, you're on the committee and you cut this deal, tell us why, give us the scoop in the background. And it's like, I can't. I mean, I'd like to, we're all the government, it's a good deal. We can tell you it's a really good deal and we thought about this, but because of our confidentiality agreement, we can't necessarily share that. So,
So I don't think we have concrete advice for you in that circumstance. I think that the takeaway is that you may be in circumstances where the agencies are going to take different points of view. And I think that when the agencies are all represented by the U.S. Attorney's Office, there's going to be an attempt to try and come up with a cohesive position. But it might not be possible, and it may be that you would have different attorneys. I have had the Department of Labor in a case before me, this is all public record, that opposed something that both the U.S. trustee and Health and Human Services was supporting, and that was a little awkward. So they ended up adjourning their matter and came back with an agreement. And sometimes time fixes things and lets people negotiate something. Because I do think the government attorneys are aware of the oddness of their dispute.
And I would say in that situation, as the AUSA, if I had agencies who had competing claims against each other and they couldn't agree on how they were going to be treated, that puts me in a very uncomfortable spot. I'm going to have to go see my civil chief And you should know at that point in time that you should build in some more time because probably it's going to take several more signatures in that uncomfortable situation. But honestly, I haven't seen that. Usually
But
the
you would
agencies get it
expect
worked
that,
out.
that if it really comes to a head, you would get direction from the
Yes.
the U.S. Attorney will decide who's going to
Yes.
prevail.
As the AUSA, I would want that.
Right. And, okay. Any other questions? Yep.
One right here.
I would like for you to, hi, I'm Beverly Mann, I'm from Pittsburgh. Worked for the feds for a number of years in my youth, which was a long time ago. But some things never change, and the federal government's one of them. Can you address very briefly for the audience what the current climate is with respect to assignments of contracts in bankruptcy and the Anti-Assignment Act with respect to the feds? So for instance, in a healthcare bankruptcy, you have your issues with CMS and your provider agreements, and you may have issues with the Commodity Credit Corporation with respect to the assignment of PIC agreements. So just a really brief comment, because when I get into cases and we're dealing with the government, I find a lot of debtors' counsels and creditors' counsel are unfamiliar with this, and it might be useful to tell us really briefly what your thoughts are on that.
So Jamie, I don't know if you have any experience with the anti-assignment clause in it, or provisions.
But I can tell you, if you contacted my office and told me that, I would find someone who does. Because we don't know everything there is to know about every governmental agency. There's just too much. So if I get an attorney that calls me and says, I have this very specific issue, I'm going to say, hey, I don't know anything about that, but let me dig around and find you someone, because we want to make sure we get you the correct information and that we don't do anything to stop the progress of the case. So when I get something like that, I'm going to find out who does know, because there is someone, probably here in DC, that knows the answer to your question.
And to be honest, I don't know the answer to your question either. I will say that there are a number of pockets of federal law, including the Anti-Injunction Act and some the Anti-Assignment Act that you're talking about, that are unknown to many practitioners. And so I think when you have that kind of an issue come up, the theme is early is better, to try and give everyone time to address it. Anyone else? Anyone have issues come up in, do we have any consumer practitioners in the room? Folks, not many, okay.
As consumers deal with, I mean, you don't get to deal with the PBGC, lucky you, but you do get to deal with federal agencies, you know, Treasury, Education, and the U.S. trustee. Everybody who practices in bankruptcy will deal with some government agency.
Okay, any more questions? Okay, any more from the panel? I think we're good. Well, thank you so much for having us.
Thank you for, oh, does it work? Thank you, Chip. Okay, thank you. There we go.
Can you hear me now?
Yeah. Thanks to the lovely panel today for a really informative discussion. And I have some gifts for you before you go. We're going to take a 15-minute break. So come back at 10:30 for our anniversary celebration and a tribute to Celinda Melnick. And try to be on time if you will, because you're going to find we're in a little bit of a time crunch this afternoon. Thanks.